Welcome to our webinar on the top 10 impacts of President Biden's executive order on outbound investment, important implications for funds and investors. My name is Robert Friedman, and I'm a partner in the International Trade Group at Holland Knight. I'm joined by my partners, Antonia, Tzinova, and Andrew McAllister, who you'll be hearing from shortly. We're pleased that you've joined us this afternoon for what we hope is a informative and fully packed hour of topics related to the new executive order. A couple of comments at the outset, just to sort of set the stage. The format of this webinar is sort of a lightning round. We're gonna tick through 10 topics in short order, but we would like to hear from all of you. So please take the opportunity to ask questions in the Q&A feature of the webinar, and we'll be sure to leave time at the end to answer those questions. What you're going to see what you're going to hear from all of us is that there's a definitive framework for outbound investment that the executive order and the proposed rules set forth, but major issues for businesses and investors will be determined by the final shape of the implementing regulations. And there's a lot of topics that are not yet fully settled. And so in the event that you hear aspects of this webinar and you think your business will be impacted, there is still time for you to comment. The public comment period runs through September the 28th, so you have just under 30 days, and the Treasury Department is very interested in hearing from the regulated community. So the first issue, just to kind of set the stage and the framework for the executive order, is that the EO and the proposed rules contemplate both a prohibition and notification element. At the time that the EO was published, there was an annex, and only one country was listed, and that is China. And that includes Hong Kong and Macau. And although the annex only addressed one country at the outset, the executive order does not preclude other countries from being added if those countries meet the criteria for designation. So we're going to be focusing our discussion on China, but please keep in mind that the framework is not exclusively focused on China, and in the future, there could be other countries that would be subject to analogous restrictions. So as I mentioned, the proposed rules outline a program that would either prohibit or require notification to Treasury of specified investments by U.S. persons into foreign entities engaged in activities related to technologies or products of national security concern. Notifiable transactions, which is the broader sort of bucket of transactions, are categories of transactions that involve technologies and products that may contribute to the threat to national security of the United States. And prohibited transactions, which is a smaller subset of transactions, involve technologies or products that pose a particularly acute national security threat because of their potential to significantly advance the military intelligence, surveillance, or cyber-enabled capabilities of countries of concern. So just to summarize, there's a broader set of notifiable transactions and a narrower set of transactions that are prohibited. In one sense, the regime that's being proposed for U.S. investors creates essentially two binary choices that must be self-determined by the investor. The first is transactions will either be prohibited or not, or they will be subject to notification requirements or not. Unlike the inbound review program that many of you are familiar with in the CFIUS context, in the proposed rules, Treasury stated that it does not intend to conduct a case-by-case review of outbound investments. Rather, the proposed rules envision the onus being placed on transaction parties and primarily U.S. investors to determine whether a given transaction is prohibited, subject to notification, or permissible without notification. Just two more points, and then I'll let my colleagues take over. The first is that although there are these two categories of prohibition and notification transactions, the proposed rules mention that there could potentially be either a carve-out or a licensing regime for transactions that are in the national interest of the United States. So this implies that the Treasury might envision a similar system that OFAC has with licensing for individual transactions that might be subject to a national security exemption. The proposed rules set a very high bar for these carve-outs, and they would need to present extraordinary benefit to U.S. national security. So there's a contemplated licensing aspect to this, but it is a pretty high bar that would be likely needed to be satisfied. Only other point I'll mention at the outset is that the effective date of these new rules are really the effective date of the regulations whenever they come into effect. But there is a aspect of this that everyone needs to be aware of. The proposed rules indicate that Treasury may inquire about any investment made after the date of the executive order, even if those investments were made prior to the implementing regulations. So although we do have some time before the final rules will be effective, transactions that occurred at any point after August the 9th, which was the date of the executive order, going forward, companies need to be mindful of those investments in the event that there's a need to engage with Treasury on those investments. So next, I'll turn it over to Andrew, who's going to talk about some of the covered sectors.
Thanks, Robbie. Appreciate it. So the second point we're going to hit on is the covered sectors. And I think at the outset, it's important to note, although the executive order is focused on the three sectors on the slide, there are certainly instances where we could see an expansion in the future to other sectors. I think it's important also to note that in parallel to this executive order, there's also been occurrences on Capitol Hill. And so one of those acts that's been voted on at the Senate level is referred to as the Outbound Investment Transparency Act. And the reason I mention that is, in addition to these three key sectors, that act that's been voted on by the Senate includes three other sectors: hypersonics, satellite-based communications, and networked laser scanning systems with dual-use applications. So I think that's just illustrative of the potential of, future expansion in this area, whether it's through, additional legislation or through executive action. I think also, as Robbie mentioned, given sort of where we are in the state of these regulations, this is really the key opportunity for parties to provide comments, to try and clarify what these three key sectors actually mean in practice. Most of the discussion in the current Federal Register notice is fairly broad in nature. And so I think also as a backdrop, many of these sectors come from other executive action that's been taking place over the past couple of years. One in particular is under the export control regime. For instance, the Department of Commerce, Bureau of Industry and Security has a set of new regulations from the end of last year that hone in on semiconductors and microelectronics. There's also an area of potential restrictions in the so-called emerging technologies area. And so again, that's an export control term of art and would correspond to things like quantum information technologies and artificial intelligence systems. In terms of sort of those export control, I think the outbound investment, in part, it's trying to fill some perceived gaps, fill some perceived loopholes. And so, for instance, under the export control reforms, it's looked at U.S. origin components being sent to China, U.S. origin technology being sent to China, as well as naming specific Chinese companies in some of these sectors on the so-called entity list, which further restricts commodities and technologies to China. So I think in understanding these key sectors, it's crucial to be cognizant of sort of the export control landscape that contributed to the identification of these sectors. And so I'll just quickly go through semiconductors and microelectronics sort of as an example. Right under that sector, at least in the Federal Register notice, the government is considering a prohibition on sort of a subset of covered transactions related to semiconductors and microelectronics, and then also potential notification requirements. And so, again, the concerns of the government are the development of semiconductor and microelectronic technology that enables the production and certain uses of integrated circuits that will underpin military innovations. And so, again, a lot of these terms, a lot of the concepts that we're talking about here, one of the keys is sort of the military or potential military application. So you'll see that sort of crop up from time to time. And so just in terms of identifying the prohibitions that are outlined in the Federal Register, at least as potential possibilities, are technologies that enable advanced integrated circuits, advanced integrated circuit design and production, and supercomputers. And then the Federal Register also goes through some notification requirements for design, fabrication, and packaging of other integrated circuits. And so I won't go into detail about the other two areas, only to mention that there's a similar discussion in the Federal Register notice. And again, companies in these areas, it would be wise to take a look at what the sections of the Federal Register talk about with regard to those sectors to see if they're clear, if they're overly onerous, etc. So next slide, please, and I will turn it over to Antonia.
Thank you, Andrew and Robbie, and good morning, everyone. Thank you for being here with us. So just to kind of touch on big picture on what transactions will be covered by the executive order and expected regulations. We have termed this as relatively limited set of transactions, and these are in the line of acquisition of an equity interest, contingent equity interest, that could be some sort of a debt financing that's convertible, or pure debt. We'll see how it's framed in the regulations. Certain greenfield investments, establishing of joint ventures. So if you notice, the focus is on financing or kind of funding for a certain activity, and it's important to remember that this executive order and regulations are not operating in vacuum. We still have export controls and sanctions applicable. So when it comes to transfer of technology to China currently and other countries of concern in the future, you would still need to apply regulations that are existing with respect to sharing of knowledge. The idea here is to limit ability of a country of concern to develop this technology at the speed at which they are. So just kind of big picture, nobody is thinking that China would never be able to get access or develop its own artificial intelligence or quantum information technologies or semiconductors. The idea of many prior regulations and this new one is to maybe lower the speed, slow down the process and delay the process to a certain extent. And that's why the executive order is targeting money that go into such enterprises as developing the technology. I want to mention a couple of elements here that kind of relate to what Andrew and Robbie said. The order is issued on the basis of AIPA. For those of you who are familiar with economic sanctions administered by OFAC at the Treasury Department, you know that this is on the basis of national security. And the executive order directs Treasury. We don't know what office at Treasury yet will be taking over this particular program, but you know, the fact that we have prohibited transactions and notifiable transactions, the fact that it applies to U.S. persons generally, and the fact that there is an element of self-monitoring, self-regulation, are elements that make it very alike to an OFAC program. And to the extent that we see this limitation on the type of transactions that are being targeted, we can view this as a kind of more limited, focused embargo program. Whether that will be handled by CFIUS or by OFAC or by a new office, we are yet to see, but we definitely see some sort of elements here. Pass it back on to Robbie.
Great. Thank you, Antonia. So I think the next topic is focusing on some of the exclusions or the accepted transactions that are contemplated in the proposed rules. If you take the Biden administration's statements, at face value, they're very committed to narrowly scoping these restrictions into, really focusing in on the transfer of capacity building in China for certain kinds of technologies that are a threat to national security. But the types of transactions that are not subject to the proposed rules, that are at least contemplated in the proposed rules as being carved out, are largely passive investments, in smaller investments. And those are excluded from the definition of covered transactions because they're viewed as not presenting the same kind of national security concern as some of the areas that we've covered to date. So the proposed exceptions include different categories of transactions. These would include investments into publicly traded securities, investments into index funds, mutual funds, exchange traded funds, or similar instruments. And importantly, investments made as a limited partner into a venture capital fund, a private equity fund, or other pooled investments where the limited partner's contribution is passive and it comes below a minimum threshold. So some of those concepts will be familiar to practitioners in the CFIUS field. So for example, to the extent that a limited partner's investment in a fund is passive, we can draw on some of the concepts that underpin the CFIUS regulations. So if the limited partner doesn't have the ability, for example, to make managerial decisions or ability to formally or informally influence or participate in the fund or the covered foreign person's decision-making or operations, those are the kinds of characteristic or criteria that would make the investment passive. But to the extent that the limited partner had any rights beyond kind of standard minority shareholder protections, and these would include things like membership, observer or nomination rights, or involvement in any kind of decision-making in the covered foreign person, they would not qualify for the exception. So the proposed rules attempt to draw a distinction between investments that would be perceived as passive versus those that attach additional rights or ability of the U.S. person either in the fund or in the covered company in China. The relatively new concept is the de minimis threshold. So neither the executive order nor the proposed rules indicate what the de minimis threshold would be, or whether it would be based on the size of the limited partner's investment, the total assets under management, or other factors. Treasury has said that it is considering a high threshold where there's a likelihood of additional benefits being conveyed by the size of the investment. Things like managerial assistance for the Chinese company, talent, network access, market access. Again, these are all areas that Treasury is seeking comment in the proposed rulemaking to try to identify what that de minimis threshold should be. And I think that's a very important element to consider for U.S. investors that are investing, in pooled investment vehicles in China to try to, make that carve out or that exception as broad as possible so as not to impact a large swath of investments. There's additional proposed exceptions around specific other kinds of transactions. One is a 100% acquisition by a U.S. person of all of the equity, assets, or other interests held by a covered foreign person in an entity located outside of China. So essentially, this would be if a U.S. business is buying a non-Chinese subsidiary of a Chinese company, buying the entire company, that would not be a transaction that would be subject to either prohibition or notification if it met those criteria. So again, that's an area that's subject to the rulemaking and should be a focus of any comments that are submitted. An intercompany transfer of funds from a U.S. parent company to a subsidiary. This is another area that I think is critically important for U.S. investors to consider and U.S. businesses to consider that have operations in China. If that exception or that carve out is broad and robust, then it wouldn't prevent U.S. companies that have Chinese subsidiaries from supporting those Chinese subsidiaries through capital expenditures or other transfer of funds that might support ongoing operations. But if that exception is limited or carved out or narrowed, then there could be problems for U.S. companies that have Chinese subsidiaries. And then the final area of the definitions that are proposed to be excluded are certain enumerated activities. These include university-to-university research collaborations, contractual arrangements, or procurement of material inputs, such as raw materials for covered national security sectors, intellectual property licensing arrangements, and other secondary activities to cover transactions, things like bank lending, processing, clearing, or sending payments by a bank, underwriting services, and prime brokerage. Next, I'll turn it back to Antonia.
Thank you, Robbie. So a little bit on the scope of foreign persons covered by the executive order and proposed rule. And now here we see a reversal. While we have a relatively narrow scope of sectors and transactions targeted, we have a relatively wide scope of persons that will be captured under the definition of covered person. And it's notable that these are persons that own controlled nationals of the country of concern, but it's also their subsidiaries or entities over which they have control. As such, a covered person could potentially include the U.S. or foreign subsidiary of a Chinese or even non-Chinese entity if ultimately majority ownership or control can be tracked back to a Chinese national or Chinese company. And that is important. That's going to affect some of the activities in the U.S. And it's good to kind of take note, and to the extent that businesses see unintended consequences here and impact on business activities in the U.S. or Europe, for example, or in allied countries. Make sure you make yourselves heard before the final rule comes out. But we believe by reading the proposed rule, the definition and some of the examples given, that the intent was to capture those subsidiaries of Chinese entities. And the majority owned or control is kind of important to remember. I mean, in China, for example, if a foreign company goes in, there is the requirement of a local partner that owns majority of the equity. You have similar constructs around the world. This rule seems to be kind of mimicking this, although it's a hidden requirement of a majority U.S. ownership in a U.S. company that's foreign owned. But it's kind of suggesting that if a U.S. person is able to control the U.S. subsidiary or the foreign subsidiary, the transaction will be outside of the scope of covered foreign person. And so that is something to consider in structuring investments and negotiating joint ventures with entities of countries of concern. As mentioned, includes U.S. and foreign subsidiaries of companies organized in China which is the only country of concern currently, has the potential to affect multinational investment targets with downstream Chinese subsidiaries. I also want to mention that this executive order has been closely coordinated with European allies. So we should expect to see something similar coming out there, so that US investors are not unduly burdened and disadvantaged in comparisons to investors from other countries, but keep in mind. And with that, I'll pass it back on to Andrew.
Great, thanks, Antonia. So, issue that's been hit on a couple of times would be U.S. companies with Chinese subsidiaries. I guess as an initial point, this probably makes logical sense to most, but certainly a Chinese subsidiary of a U.S. company would not have sort of full safe harbor. It wouldn't be sort of taken out of the covered transaction aspect if, for instance, it's getting funding from another U.S. company. So company A, U.S. company, say, owns company B, a Chinese company, and company C, another U.S. company, is investing into company B. The notion of sort of an accepted transaction when it comes to a Chinese subsidiary would not cover that situation. I guess one point that sort of builds on something Antonia said is when you look at the exception, what is going to be the standard for a Chinese subsidiary that is considered to be owned by a U.S. person, right? Most likely situation may be 50% or more ownership, but you may have more complicated situations where, let's say there's 5 investors into a Chinese company. The largest is a U.S. investor at 25%. Well, that may be a situation where it's not going to be quite as clear cut as to whether a Chinese subsidiary might fit into that accepted set of transactions. In the Federal Register notice, it does go out of its way to point out that it's not intended, so the restrictions are not intended to cover an intra-company transfer of funds from a U.S. parent company to a subsidiary located in a country of concern. That would be China. But then it goes on to say, explained as most routine intra-company actions, such as the sale or purchase of inventory or fixed assets, the provision of paid services, the licensing of technology, the provision of loans, guarantees, or other obligations. And so can certainly imagine a situation where activities by a U.S. person might go outside of what Treasury or the government would consider as sort of routine intra-company actions. Let's say there's an effort by a Chinese subsidiary to acquire an existing manufacturing plant, right? Is that really the type of thing that the U.S. government would be willing to allow the Chinese subsidiary to carry out on behalf of the U.S. person? Or is that something that potentially could go over the line? So I think certainly there are going to be comments and some ambiguities around, are we talking about investment type capital? Are we talking about more operational capital where, hey, the Chinese subsidiary is not as profitable as it was last year, therefore we need to infuse some relatively small working capital into the Chinese subsidiary. That I think is certainly one situation, as opposed to investment capital where there's purchase of real estate to further the Chinese business or something like that. And then I guess another area that was mentioned by Robbie is the Federal Register specifically talks about and asks for comments on the impact if the exception were applicable only to relevant subsidiaries of the U.S. parent before the date of the executive order. So that would be existing U.S. subsidiaries as of August 9, 2023. And so is that a tip by the U.S. government to say, okay, we're grandfathering certain Chinese subsidiaries into this sort of accepted bucket, but we don't necessarily want U.S. persons out there purchasing Chinese subsidiaries after this order to sort of further or bolster a foothold in China. So again, I think there are a number of issues that are still to be sort of worked out and clarified on the Chinese subsidiary. So I will turn it over for the next slide.
Great. Thanks, Andrew. Those are really, I think, important points and definitely topics for impacted businesses to consider commenting to make clear to Treasury the preferred scoping of some of those provisions. So the next topic we want to go over is the potential for global reach of these proposed rules. Antonia and Andrew have talked about how non-Chinese investment targets might be brought in to the proposed rules, as well as certain Chinese subsidiaries of U.S. persons. I'm going to focus now on the way in which these rules have the potential to impact non-U.S. investors. So, funds or investors outside of the United States that might have some U.S. touch point. And again, at face value, this is intended to be a U.S. investment screening regime in China, but there are a variety of ways in which non-U.S. investors could be impacted. So as an initial matter, the Treasury program anticipates that U.S. persons, wherever they're located, will be responsible for adhering to the prohibition and notification requirements. And the definition of U.S. person it will be familiar to many businesses and practitioners that comply with OFAC sanctions, because it tracks largely the definition of U.S. person in those regimes, includes a U.S. citizen, lawful permanent resident, entity organized under the laws of the United States or any jurisdiction within the United States, including any foreign branches, and any person physically in the United States. Again, this is consistent with the definition of U.S. person in various sanctions programs. However, under the EO, the Secretary of the Treasury also can place obligations on U.S. persons with respect to foreign entities that they control, and in certain situations where U.S. persons knowingly direct transactions by non-U.S. persons. So again, this has the potential to impact a variety of non-U.S. businesses. The proposed rules set forth illustrative examples of potentially permitted and prohibited conduct in the fund context. And I'm going to go quickly through a couple of them. So the areas that are potentially prohibited would be a U.S. person who's a general partner or manages a foreign fund that undertakes a transaction that would be prohibited if performed by a U.S. person. So you could have a general partner who's a U.S. citizen, either sitting in the U.S. or sitting, anywhere outside of the U.S., but is directing or managing a foreign fund. Those activities would be potentially prohibited in the same way that they would be prohibited if that fund manager was performing those functions on behalf of a U.S. investor. Another area is a U.S. person is an officer, senior manager, or equivalent senior level employee at a foreign fund that undertakes a transaction at the U.S. person's direction, when the transaction would be prohibited if performed by a U.S. person. So again, the potential to impact a variety of non-U.S. companies that employ U.S. persons in senior level positions in the company. And finally, a U.S. venture partner who launches a foreign fund would also be an area that is potentially subject to regulatory scrutiny based on the proposed rules. There's also another example of a likely permissible activity, and that would be a U.S. person serves on a management committee at a foreign fund, which makes an investment into a person of a country of concern that would be prohibited if the transaction was performed by a U.S. person. And so, the distinction that is being drawn there is between someone who has a role on a management committee, but does not, but the rules go on to say that the person would need to recuse himself from a particular investment that would be a covered investment. So by virtue of the U.S. person's presence on the management committee of a foreign fund by itself would not render all of the investments prohibited, so long as the U.S. person recused himself or herself from particular investments that would be covered. The other point to keep in mind is that non-U.S. subsidiaries of U.S. persons might have obligations under the proposed rules. The program would impose obligations on U.S. persons who control a foreign entity to notify the U.S. government of transactions and take reasonable steps to prevent prohibited transactions to being undertaken by a controlled foreign entity. So what does that mean? Is essentially it places a compliance burden on a U.S. parent company that might be undertaking activities through a foreign 50% or greater owned subsidiary outside of China with regard to activities inside of China that would be prohibited if taken by the U.S. parent. So again, it casts a broader web of restrictions on multinational companies that might operate through non-U.S. entities. So Antonia, I think, is going to talk now about some of the potential penalties under the regime.
Thank you, Robbie. I mean, we know that it is intended to assess civil penalties in certain cases, failure to timely notify transaction, undertaking a prohibited transaction, making material misstatements or material omissions of fact when providing information to the Treasury Department. These all sound very familiar. Again, I mean, the two parallels we have are the CFIUS regulations with recently published guidelines on penalties, and we have OFAC sanctions programs with very well-established rules on the type of sanctions imposed. This executive order is published under IEPA, so if this is any indication, both in CFIUS and in OFAC sanctions, we have a $250,000 per violation. This can go up to the value of transaction. It can be multiplied on the basis of accumulation, meaning one act may constitute different violations of different rules. So we are yet to see how this shapes up, but I think that's kind of an indication of where to expect the regulations to develop. Similarly, both OFAC and CFIUS have published guidelines on mitigating and aggravating factors. So we should expect to see that also in the future. There is not much more to speculate about until we see the final rule. I think back to Andrea.
Thanks, Antonia. So just, I guess, sort of as we start to wrap up the discussion, certainly, as we've said before, that this is the opportunity for the public to file comments. This is currently, advance notice of proposed rulemaking. There's certainly, I would say, a pretty good chance, given the foreign affairs function of the outbound investment program, that we would advance from sort of the state we're in now to at least an interim final rule subject to refinement, subject to additional comments. So again, this is certainly the public's opportunity. I guess just a couple of further things, and this was referenced earlier, but I think given that only China is referenced as the country of concern, it sometimes causes, I think, parties to say, okay, well, I don't do business in China right now, therefore this doesn't directly impact me. And I think the Outbound Investment Act that was signed by the Senate shows us or leads us to believe that that may not be the end of the discussion, right? Countries such as Russia are specifically named in that Outbound Investment Act. And so it would not take much for a country like Russia to be added as a country of concern. So I think in sort of thinking about whether there's a benefit in filing comments, it's both thinking about, well, are there other sort of countries that we do business in that could eventually be impacted? Or are there other sectors of sort of a critical nature, either that we've seen through export control actions over the past couple of years, or in other areas that may make us believe, okay, well, we need to make sure the rules are workable for us because there's some risk that down the line our sector could be added. So I guess a few in terms of looking at the Federal Register notice that requested the comments. There are 83 unique prompts for information that Treasury is asked about. So quite a bit of opportunity for comment. Conveniently, I would say Treasury has sort of segmented it into different areas, whether it's definition of a U.S. person, whether it's the knowledge requirement, whether it's the three sectors that are mentioned here, semiconductors, quantum information technology, or artificial intelligence systems. So there's even a way, at times, the Federal Register notice is, I guess, sort of overwhelming, but there is a way to hone in on particular areas if you feel that there are particular definitions, particular examples that would be helpful to explain to the government. In some ways, there's probably certain areas where there's not likely to be a huge impact from comments. One I would take, for instance, is the definition of a U.S. person. That's mentioned in the Federal Register notice. There's a few prompts on how that term's defined, but it's, as Antonia mentioned, it's already defined in Treasury's OFAC sanctions, and it's already defined in the executive order. So that, again, that may be an area that's not as ripe for comments, but then we turn to other areas, right? Timing of notification requirement. There's a reference that, it may be up to using a deadline of up to 30 days after the closing of a covered transaction. Actually sounds pretty good if you ask me, but there's no guarantee that that's going to be the final rule. For instance, in the Outbound Investment Act that the Senate's been considering, there are different standards on when notification would be required. So I think that's one mention. Another sort of interesting area, and this may be more theoretical, is how is the Treasury Department going to deal with a prohibited transaction, right? For instance, a company makes an acquisition of a French company which has a wholly owned Chinese subsidiary in this area. Well, how's the U.S. government going to enforce that? The transaction itself may have taken place in another country, and so there may be some jurisdictional challenges. Another areas I would say, which we hit on earlier, is the nature of accepted transactions that are sort of taken out of the covered transaction definition. I think that's an area where companies can have a big impact by illustrating to the government real life situations, illustrating to the government certain policy rationales for why X should not be considered a covered transaction. So again, there are lots of areas. The Federal Register does a pretty good job of making those prompts, but certainly things that are not specifically prompted in the Federal Register can still be commented on. So I will stop there and turn it over for the last one to Robbie.
Thanks, Andrew. And just as a reminder, I'm going to cover the last item on our top 10, but please, if you have questions, use the question and answer button on your webinar and feel free to pose anything that is on your mind, and we'll do our best to answer those questions. So, I think the two biggest takeaways from this entire presentation are, one, that there's a number of areas that are really important for the public to consider commenting on, areas that are undefined, areas that the Treasury Department is seeking input from the regulated community. And then the other, which I'm about to cover, is preliminary compliance considerations. And the reason that these are topics that I think are critical for businesses to consider is because although the effective date of the regulations is still many months away, August 9th is the trigger date when the executive order was issued for many of these considerations to be implemented by companies that might have consummated transactions after the 9th of August, because Treasury can begin to inquire about transactions that would be covered after that date. So these compliance considerations are things that investors that are active in China should already be considering and implementing. So we've discussed the prohibitions and the notifications that are pertinent for different classes of transactions, but the proposed rules indicate that the determination of whether investments are prohibited or require notification, as well as the risk of getting that determination wrong, is squarely on the shoulders of investors. Although Treasury will be defining the classes of transactions that are prohibited and require notification, the focal point of deciding, when to submit a notice or when to, ensure that a transaction is not consummated is really on the investor. And so that requires the investor to analyze some pretty complicated topics that are not always clear, including whether a contemplated investment activity involves a party from a country of concern, whether a sensitive technology or activity is itself covered, and that started after the 9th of August. And so I just want to walk through kind of our initial thoughts on compliance considerations that are pertinent for investors who are active in China. First is U.S. persons that are active in covered technology sectors outside of China and in the United States, including in the European Union, Taiwan, and elsewhere, can be expected to perform more robust due diligence that traces investment target ownership or control to the very top to ensure that no non-Chinese companies that are located in third countries are ultimately owned or controlled by Chinese individuals or entities. So again, that due diligence expectation will look at ownership or control to the very top of investment targets. The second is that U.S. persons should be expected to perform broader due diligence of large and opaque Chinese investment target companies. So the executive order does not distinguish between Chinese companies that exclusively operate in the covered sectors and those that may have certain business units or affiliates that engage in those activities. Depending on how the rules are written, U.S. persons investing in what they believe, for example, could be a Chinese company that makes playground equipment, could be considered a covered foreign party if other parts of that Chinese business are operating in the covered sectors, semiconductors, quantum, or certain kinds of artificial intelligence. So for U.S. investors, it's important not only to do diligence up to the top of the ownership chain, but also do a broader diligence within all of the sort of operating entities or affiliates of Chinese companies to determine whether there could be business units or activities that would be covered, even though the aspect of the Chinese company that you're engaging with or investing in is not obviously covered. Number three, U.S. persons should consider developing internal controls to detect and report potentially in-scope transactions to either in-house compliance professionals or to outside counsel to determine whether the new rules are applicable or not. This is particularly important for companies that have high volume of investments in various sectors in China. So again, these are not focused on external due diligence, but focused on internal controls and reporting so that the right people within your company have the ability to identify potentially covered transactions. Number 4 is to U.S. persons should consider record keeping to demonstrate compliance with the new executive order and proposed rules. Just as a warning or a best practice, the statute of limitations for programs that fall under IEPA is typically 5 years. So if you're looking to kind of build an internal control around the length of time that records should be kept, that's a good frame of reference to consider. And then finally, U.S. persons may want to consider contractual representations and warranties that address whether a target is a person of a country of concern and whether activities might be covered activities in the target. These covenants and other contractual limitations will be helpful for U.S. persons to limit liability, and also, frankly, it shifts. Well, it helps with the compliance burden that would otherwise be applicable to U.S. persons that are going to be relying on investment targets to furnish information to make that self-determination, right? So if a U.S. investor is considering a Chinese target, it needs to know whether the Chinese target company is engaged in quantum computing that would be covered. That information may not be readily available to the U.S. investor, and the U.S. investor may be reliant on the investment target to furnish the information. So either through a due diligence process or through contractual representations and warranties, that information needs to be in hand prior to the investment.
Okay, thank you, Robbie. And with that, we hope we gave you some good information, kind of big picture. And we have a few minutes left for questions. We have a couple of questions. So the first one that is if most important probably to people, will we have access to the presentation slides? Yes, we will share them to all people who registered for this program. So you'll get the slides. The next question that we have here is when do we have a sense when the rules might go into effect? Andrew, do you think?
Yeah, so I mean, I think in terms of the government's consideration of the comments, there's no sort of required timeline. There's right, when it's a foreign affairs function, the government has great discretion to sort of go out and make rules whether or not it considered the comments or not. But I would suspect, the comment due date is around the end of September, and so I would guess the likeliest answer is the regulations will probably go into effect maybe sometime in the first quarter of 2024. But again, we're sort of reading the tea leaves. We don't know the answer for certain, but I think that's at least a reasonable timeline.
Thank you. And one that's kind of aligned maybe with this one, can comments be submitted as business confidential information, or will the name of the submitting company be released to the public?
Yes, so in terms of the comment submission, I believe, that the names of the companies may be public. Certainly, companies sometimes make comment filings through a legal representative or other third party, trade association, organizations like that. That being said, there is a mechanism by which business confidential information can be provided to the government, but it's not distributed widely to the public. So what you would do is create a business confidential version of the document, and let's say page 3 had very specific information about your company's semiconductor production process. There is a mechanism by which that information could be summarized publicly for the document that would be distributed sort of openly to public parties.
Thank you. I think that's very important for businesses to understand that if you want to comment on the proposed rule, there is a way to submit confidential information that's not going to become public. Another one, maybe Robbie can take this one. Is there a process for U.S. investors to use to self-determine whether they're subject to the prohibition or notification requirements that are spelled in the executive order and proposal?
Yeah, it's a great question, and it's a real challenge, I think, for U.S. investors, because at least according to the commentary in the proposed rules, Treasury does not intend to do a case-by-case analysis of outbound investment. So, unlike an inbound kind of CFIUS review where there can be a submission and CFIUS will determine whether or not there's a covered transaction and whether or not and the conditions on which clearance will be rendered. For the outbound investment regime, it's really up to individual investors to make the determination of whether a notification is expected or whether a prohibition would apply to a proposed transaction. What we don't know and what is unclear is whether, in the same way where CFIUS has what's called a non-notified transaction inquiry process, whether this new outbound regime will have a similar process whereby if there are investments in China or in third countries involving Chinese companies, whether Treasury will inquire with the transaction parties after the fact to determine or understand whether there was a covered transaction or not. That is an open question at this point, but I think it underscores the importance for U.S. investors to really do robust diligence upfront and get comfortable with the fact that there's not a covered transaction target, or that the area of investment is not a covered industry or covered sector. So doing that diligence upfront and documenting the determination will hopefully insulate U.S. investors from some of the potential downside risk involved.
Thank you, Robbie. Last one in my queue. Should we expect congressional action on this topic? I believe Andrew briefly mentioned this, but just to bring this into context, this is not a new development. We've been waiting for some action in this area on outbound investment for the last almost 2 years more. There have been proposed legislation both in Congress and in the Senate. There are differing opinions right now of what should be captured, how broad the action should be, whether we should rely on existing regulation, maybe existing export control regimes, or whether we should go more broadly after money, as I said, which was the target here, and funds available to Chinese companies. And so I think that the industry came to expect a more limited action by executive order, which we saw a couple of weeks ago. This was very carefully negotiated with partners, and it's kind of a test. I believe that they will be testing the waters to see what is the effect, how it's actually implemented in action. We know that the CFIUS regime initially started as an executive order, and later on it was codified in law. And so it is very possible that this is going to be based on trial and error, and we're going to self-correct the course, and maybe at some point it will culminate in a congressional action. But the positions right now are too differing to see something very coherent in this area. So I think beyond that, it will be relying on a Ouija board. Okay, one more question. COE or CPE for attending? I don't believe so, because this was announced very late. So not sure if we actually can get that, but I'll leave that to our administrators to address. If we are able to get COE, we'll get in touch with the audience.
I think we're up to an hour, and just want to thank all of the participants for joining us this afternoon. If there are questions that were not answered, please feel free to email either Antonia, Andrew, or myself, and we're happy to follow up directly with you. It's been our pleasure to go over this outbound investment screening regime, and we look forward to future dialogue.